Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. In this week's video, we're in session number 5 of our new program entitled QME Hot Topics and Pop Culture. And in this series of discussions, we're talking about some of the latest issues that are circulating around the QME industry and QME community. And we're uncovering some of the important concepts that are very, very relevant in this exact day and age for us as qualified medical evaluators. Today we're in session 5, and I have a fabulous program for you today, one that's going to be an eye-opening experience for you for now and for moving forward in each and every one of your evaluations now until the end of your career as a qualified medical evaluator. And these are some of the topics that we've discussed so far in this program. We spent great time talking about the concept of liberal construction and how we can apply that concept to each and every one of our evaluations, especially those evaluations that involved denied claims for which the examinee comes to us for an AOE and COE determination. In session number 2, we spent quite a bit of time talking about work restrictions and your return to work recommendations and how important accurate return to work recommendations are, especially for the injured worker, where the stakes are extremely high and where the injured worker may or may not be able to return to the pre-injury occupation depending upon how you write up your return to work recommendations. So it was a very important discussion in session number 2. In session number 3, we talked about the pain-related impairment, and we talked about when, where, why, and how to properly apply the additional 1, 2, or 3% additional excess pain add-on for your examinee. In session number 4, we tackled the huge insurmountable challenge of your apportionment approximate percentages, and I greatly simplified the whole process of coming up and writing your apportionment argument in the body of your report with a simple formula that you can use every single time, and it will work for you in every single case. Today we're in the new anti-bias era. I'll talk a little bit more about that in a minute. And in our next session, we're going to talk about creative and innovative and unusual permanent impairment formulations that you may never have considered before in your cases, but which you can use into the future, and will also open your own creative mind and release creative juices within you for innovative uses of the 4 corners of the AMA guides. So in today's session, I want to talk to you about the new anti-bias era. I have quite a bit of information to share with you about bias, stereotyping, and the many preconceived notions that we bring to the face-to-face evaluation and to our medical legal report writing. And as we now enter into the new anti-bias era, and I'll explain that in just a few moments, I want to give you some of the historic perspective that brings us to where we are today on the cusp of the passage of new QME regulations that tackle the bias issue in the medical legal evaluation head on, very deliberately, very overtly, very clearly, and very aggressively. And I'll share with you now some of the historic sequences of events that have brought us to this point in time. So with that as our introduction, let's begin today's session. We're in session number 5 of our new program entitled QME Hot Topics and Pop Culture. And today we're talking about the new anti-bias era. Okay, so let's begin today's discussion, which is all about the new anti-bias era. And I want to share with you some of the historic perspective and events that bring us to the point in time where we find ourselves right now in 2023 as this is being recorded. Well, back in 2016, an important legal case known as the Page versus Perry Soto case came on the scene. And this was a case where many female injured workers sued the Department of Industrial Relations, the parent company, over the Division of Workers' Compensation, sued the the Department of Industrial Relations for what they claimed was discrimination in medical legal evaluations and discrimination related to the opinions and conclusions, and specifically the apportionment determinations being provided by qualified medical evaluators, which is us as a group. So this was a very important lawsuit, and the lawsuit faltered and stumbled, and still, to my knowledge, has not yet been resolved. But this is what introduced and brought out onto the table topics related to how bias impacts the opinions and conclusions and outcomes of our medical legal evaluations. And this was the precipitating step that brings us to where we are today. Well, later in 2021, shortly thereafter, as the impact of the Page versus Perry Soto case began to be felt, the Division of Workers' Compensation put together some new proposed changes to the QME regulations, and those were proposed in 2021. Now, those regulations have not yet come to pass, but they're going to pass in the very next few even days as this is being recorded, maybe as many as a couple of weeks, but certainly very, very soon these regulations are going to come to pass. And in these regulations back in 2021, the Division of Workers' Compensation proposed some new legislation designed to address bias in the medical legal evaluation. There's several sections in these new regulations designed to combat the problem of bias, and I'll share with you some of those pieces of legislation and how that's going to impact us as qualified medical evaluators. Well, later in June 2021, Senate Bill 788 was proposed and initially passed passage in the Senate. And Senate Bill 788 was a bill that specifically addressed apportionment and bias in our apportionment determinations. So can you imagine this? A specific bill passing through the Senate that deals with a very, very specific issue in this niche of workers' compensation that we as medical legal evaluators are involved with, and it had to deal with bias in our apportionment determinations. Now, this Senate bill did get passed through the Senate, but it was eventually vetoed by the governor, and I'm going to show you the governor's document and show you how the governor's document brings us right to where we are today, with the issue of bias being firmly dropped in the lap of the Division of Workers' Compensation. Well, time continues to pass on through, and after this, and in through 2021 and into 2022, we saw the introduction of several new cases that deal with potentially bias-related issues. Some cases such as the Lind case, such as the Wiest case, and today we're going to talk about a case known as the Brophy case. These are all cases that dealt with similar issues related to risk factors not only for injury but also risk factors for apportionment. And up to this point in time, until these cases came on the scene in late 2021 and 2022, apportionment to risk factors was prohibited by law. Law is Labor Code Section 4663. But these cases ushered in a new era wherein apportionment to risk factors for injury could provide the basis for valid apportionment. And this opened up the whole can of worms of potential bias being introduced into the apportionment determination. And in today's session, I want to share with you the Brophy case and how Brophy, the qualified medical evaluator in the Brophy case, provided apportionment due to Mr. Brophy's obesity. And as we're going to see, obesity is one of the issues that is subject to bias. Among other issues such as race, national origin, etc., weight bias is a pervasive problem in our industry. And in this case, the medical evaluator apportioned a significant portion in fact, the greater portion of Mr. Brophy's final permanent impairment to a risk factor for injury, and the risk factor was obesity. So we have these conflicting cases that come in and start to challenge existing and established law, raising the specter of bias in medical legal determinations. Well, meantime, the Division of Workers' Compensation all through this time was conducting what they referred to as the report quality committees. And the purpose of the report quality committees was and is to improve the content and quality and accuracy of our medical legal reports, including eradicating bias from our medical determinations. So those committees are ongoing and are continuing to address the problem of bias. And then finally, that brings us to this point in time, as this is being recorded in July 2023, where, as I said, these regulations that were proposed back here in 2021 are now going to pass. And I'll share with you several of the passages of the new legislation as that legislation deals with bias. So this is some of the historic perspective. Let's now talk about what is bias, what is stereotyping, and how do these issues impact us as medical legal evaluators. So as we begin to understand how bias and stereotyping and all of these issues can impact our medical opinions, let's establish our purposes for today's discussion. And we have three such purposes that we want to address. Number one is, in today's session, I'm going to share with you several examples as to how bias and stereotyping enter into the medical legal evaluation. And this is not only from the perspective of the qualified medical evaluator, but also from the perspective of the examinee, from the perspective of the parties. All of us are guilty of bringing to the medical legal evaluation our own personal and implicit biases and stereotypes. And I want to share with you in today's session just several small sampling of examples of those. Our second purpose and our second objective is to explain to you and share with you the DWC's plan through the passage of new legislation. Their new plan to combat bias in the medical legal evaluation and in our reporting. And by understanding the DWC's plan, we can together achieve the purpose of arriving at opinions and conclusions, and in writing our reports such that those reports are free from bias, free from stereotyping, free from preconceived notions, so that appropriate and accurate benefits, not understated benefits, not overstated benefits, but accurate and appropriate benefits can be provided for all persons, and such that all persons are protected from final opinions and conclusions that are colored, shaped, formed, modified, and created out of preconceived notions and biases. So we're after a sort of purity in our medical decision making on each and every case. Now, before we get into today's discussion, I want to share with you something that I recently saw at a department store that I was frequenting that illustrates the new anti-bias era. So just a very few days ago, I was at a local department store, and you can imagine that this is a sporting goods store, and specifically this is Dick's Sporting Goods store. I was at Dick's Sporting Goods store, and I was entering the men's room in the back of the store, and there was a women's room, and there was some staff rooms back there, and every one of the doors back in this corridor had this poster tacked up on the door. And this is a poster that depicts the philosophy and the policy of the management of Dick's Sporting Goods store. So at Dick's Sporting Goods store, it says here, whether you are a guest or a teammate at Dick's, we do not accept racism or discrimination of any kind. And this is an example of how this new anti-bias era is pervasive in our society. And we can see this throughout our media. We can see this in commercials on television. We can see this in advertisements and in print media. We see this all over the place, this new equality, this new diversity, and this new inclusiveness philosophy now taking place not only in California but throughout the country. And this is something that's now coming to the forefront of our consciousness as qualified medical evaluators as to how can we eliminate racism? How can we eliminate discrimination? How can we eliminate stereotyping? And how can we eliminate bias from our medical legal evaluations, just as Dix is attempting to eliminate these pervasive concepts from its management of its business enterprises? How can we as qualified medical evaluators jump on board this new inclusiveness train and become better evaluators? Well, that's the purpose and the discussion of our topic today. So let's begin by defining these issues and these concepts such as bias and stereotyping so we can understand them and see how they play out in our own medical determinations. Okay, so let's define these terms of bias and stereotyping, and let's start to wrap our own heads around how we as medical evaluators may be bringing biases, plural biases, and stereotypes into the medical legal evaluations. So bias, and this is a definition right out of Webster's dictionary, bias is a prejudice in favor of or against one thing, one person, or one group compared with another thing, another person, another group, usually in a way that's considered to be unfair. And it's unfair because whether you have a bias in favor of one group or one person, then also the other group, the other person, is going to be disfavored and is going to be unfairly considered, unfairly treated, etc. Now, these things, these persons, and these groups are what are referred to as the targets of bias. And we're going to investigate and explore several of the different targets of bias as relates to our medical legal evaluations here in just a couple of slides. So it's important to know that biases may be held by an individual, such as us as qualified medical evaluators, such as other individuals, such as by the examinee, such as by the claims administrator, etc. They can also be held by groups, or they can be held by institutions. Institutions such as what? How about State Compensation Insurance Fund as an example? I'm not saying that they hold biases, but they're an example as an institution. How about insurance companies as an institution? How about the courts as an institution? How about law firms as an institution? This is just an example of different institutions. And these biases can have negative consequences, especially for injured workers. And I'm going to share with you some cases where injured workers have suffered negative consequences as a result of biases. Okay, so that's bias. And then stereotyping, very fascinating concept, may be new to many of us as medical evaluators, except those of you that are psychologists or psychiatrists are more familiar with these issues. For us other medical evaluators, stereotyping involves assigning certain characteristics, traits, or attributes to a group of people based upon their perceived membership in that group. So we start to group individuals, we start to place individuals in groups through stereotyping, and then by the placement in that group we start to assign certain traits, characteristics, and attributes. So when you think about groups, let me ask you, what types of groups can you associate with yourself? When I think of myself, I can place myself as a member of several different types of groups. I have membership, for example, in the Bald Guys Club. I'm a bald person, and I am a member of the Bald Guys group. I'm also a member of doctors groups. I'm a member of qualified medical evaluators groups. I'm a member of groups of people that are involved in weight training. I enjoy weight training, so I'm a weight trainer. I'm a member of weight trainer groups. So I'm a bald guy who's a doctor, who's a medical evaluator, who's a weight trainer. And also I can think of at least 10 other groups that I could place myself in. And you as yourself, you can place yourself in many, many groups as well. And it's interesting because we start to assign certain characteristics to bald guys. We assign certain characteristics to overweight people. We assign certain characteristics to ethnic groups. We assign certain characteristics to different religious groups. And this is the process of stereotyping. Now, stereotyping is a cognitive process that takes place consciously in the brain that is an attempt of our brain to simplify and generalize complex social information. So we have these stereotypes that are often oversimplified and which convey or contain exaggerated beliefs about a group which may or may not reflect the reality or diversity within that group. Okay, how many times? I can't tell you how many times I've gone into a medical legal evaluation with preconceived notions about my examinee based upon my understanding of the examinee's group that examinee may belong to, and examinees themselves are their own particular group, correct? So I go into some evaluations with preconceived notions, and I can't tell you how many times those preconceived notions have been disproven as I've gotten to better know the examinee, and I find that my stereotypes did not accurately reflect the reality or the diversity of my particular examinee. So these stereotypes that we hold are often based on cultural or social beliefs, based on assumptions, or based on prior experiences, meaning prior experiences that we ourselves have had with particular groups. Imagine how the media and television and our movies serve to perpetuate these myths. For example, if you think about the group of Hell's Angels motorcycle riders, what type of a stereotype does that bring up to you in your mind? It brings up to you certain characteristics of rebellion, of carelessness, of lawlessness, of fear of getting beat up by members of Hell's Angels. And we have these stereotypes of these different groups that we bring to the medical legal evaluations, which many times are not true at all. They're simply based on our prior beliefs, on our assumptions, or our prior experiences. And we want to get to a point in our maturity as medical evaluators where we can complete our medical legal evaluations free from these biases, free from these stereotypes, such that we can actually provide opinions and conclusions that are accurate and are not colored by our baggage that we bring to the medical legal evaluation. So bias is a prejudice in favor of or against one thing, one person, or a group, and these things, persons, and groups are referred to as the targets of bias. So let's talk a little bit more about the targets of bias. We can subdivide the targets of bias into two major groups for our purposes. One is the person targets of bias, and the second are the characteristics targets of bias. So let's discuss these a little bit and see how these different targets of bias present themselves in the medical legal evaluation. Well, in the medical legal evaluation, some of the person targets of bias include, of course, the examinee, the star of the show. The examinee is the main player in the show, and so the parties, including us, including the claims administrator, can have biases against the examinee. There can be biases against the applicant attorney. There can be biases against the claims administrator. There can be biases against the defense attorney. There can be biases. The parties can hold biases against us as qualified medical evaluators. Now, when it comes to person targets of bias, let's see how this impacts you. Have you ever developed a bias of your examinee based on certain group attributions you apply to this particular examinee, such as racial groupings, such as ethnic groupings, such as religious groupings, such as body size groupings, such as socioeconomic groupings, etc. Of course you do. We all do this. And we have we have biases either for or against the applicant attorney based upon our prior experience and our prior dealings with the applicant attorneys. And we have biases against the claims administrator for 100 different reasons as to whether or not they take our calls or pay our bills or provide cover letters on time versus on the morning of the appointment, etc. And we have all these person targets of bias. Now, in addition to person targets of bias, we have characteristics targets of bias, and each of these are not independent. They're all collective and collaborative and overlapping and overlying each other. And we're going to see how this portrays out in our evaluation. So some of the characteristics targets of bias include some of the characteristics targets of bias include some of the following, and this is not a complete list. It's very, very interesting because in California Code of Regulations 40, this is known as the disclosure requirements, and you're probably familiar with this section of the regulations. CCR 40 talks about race, sex, and gender, sex meaning gender identity, national origin, religion, or sexual preference as some of the biases that if the examinee feels that we as the medical evaluator have any of these biases during our medical legal evaluation, the disclosure requirements under CCR 40 tell the examinee that the examinee can depart and leave the medical legal evaluation for what is referred to as good cause. So good cause for the examinee to leave, to discontinue, to abort the evaluation includes a feeling of bias from the medical evaluator along any of these lines. Now, these are the particular characteristics that are described in the limited regulation of CCR 40, but this is going to be expanded now with the passage of the new QME regulations that are pending even as we record this session today. So in addition to these characteristics, also other characteristics are targets of bias. Characteristics such as age, and you may have heard this referred to as ageism. I see ageism discussed frequently in the AARP magazine, which I get. Okay. Marital status, and think about what type of bias you might have if you were to learn that your examinee at age 17 is married, or your examinee at age 50 has never been married, or your examinee at age 35 has been married 4 times. In other words, we have these particular biases that we have regarding marital status. Disability and physical abilities are characteristic targets of bias. Weight and body size, also known as sizeism, and we're going to discuss sizeism in more detail here in a few minutes. Socioeconomic status and many, many other characteristics are subject to bias. Okay, so these are some of the prevailing characteristics that we commonly encounter. And I just want to expand a little bit on one of these because it's one that's receiving great attention now in the media, and it has to do with weight bias, also known as sizeism. And I'm going to share with you a case that deals with some apportionment determinations on the basis of obesity here in just a couple minutes. So weight bias in particular refers to prejudice, stereotypes, and discrimination based on a person's body weight or size. So sizeism involves negative attitudes, negative beliefs, and negative judgments towards individuals who are perceived as being overweight or having a larger body size. Now let me ask you, are you currently under the bias of sizeism? Do you currently have negative attitudes, negative beliefs, negative judgments towards people who are of large body size? Do you have any of those? I'm telling you, and I've read in recent studies, that sizeism bias is a pervasive problem in our society and even in the medical industry, where persons who have large body sizes are discriminated against and for a variety of reasons receive substandard or many times inadequate medical care. And we as qualified medical evaluators need to be particularly sensitive to these issues in our medical legal evaluations. And I'll share with you a case that illustrates this principle here in a couple minutes. So this is not a complete list. We have person characteristics of bias, person targets of bias, and we have characteristic targets of bias. Let's take some of these persons and some of these characteristics and bring them together and see how some of these issues impose themselves on us in the medical legal evaluation. So let's take some of these ideas regarding person targets of bias and characteristics targets of bias and see how they might play out in the medical legal evaluation. Well, to do that, let's just consider some of the parties that are involved in the medical legal evaluation. Each medical legal evaluation has several parties. Well, one of which, of course, is the examinee. So let me ask you, do you as the qualified medical evaluator, do you make judgments? Do you have beliefs? Do you have attitudes? Do you have stereotypes about the examinee based on the examinee's age, based on the examinee's race, based on the examinee's either gender or gender identity? Do you have attitudes and beliefs based upon the examinee's physical abilities, based upon religion, sexual preference, weight, national origin? And the answer to this is whether you have negative attitudes or beliefs about one or the other or a combination. We all develop attitudes and beliefs of our examinee based on a variety and based upon the interplay of many of these different characteristic targets of bias. And the purpose of this program and the purpose of the Division of Workers' Compensation in passing new legislation is to help eradicate these negative and preconceived notions so that we can render accurate opinions and conclusions. What about the claims administrator as one of the parties in the case? Have you ever had an opportunity to interact with the claims administrator beyond, say, for example, your interaction through the cover letter? Have you ever had an opportunity to have your staff speak on the phone to the claims administrator or communicate through email communications with the claims administrator? We can all draw inferences about the claims administrator's age, about the claims administrator's gender, and many times over the phone you can pick these things up simply through the claims administrator's voice. Okay, we can make judgments about the claims administrator's age. We can make judgments about the claims administrator's gender identity simply through tone of voice over the phone. We can make judgments about the claims administrator's cooperativeness or lack of cooperativeness, which can then impact our medical decisions from that point forward. Can you believe that? This is very, very fascinating. We make judgments about the claims administrator based upon the cover letter that we get. For example, what do you think about the claims administrator that provides to you a generic boilerplated, templated cover letter with absolutely no customization or details specific to your examinee? What do you think of that claims administrator compared to a claims administrator that provides you with a very painstaking, elaborate, and very detailed cover letter? You create a different impression in your mind about that particular claims administrator, which then impacts you and influences your medical decision making from that point forward. Whether you believe that or not, it does. What about the claims administrator who has failed to reimburse your properly documented medical legal billing on several occasions in the past? What type of negative belief does that create for you about that claims administrator? I think you know where that's going. What about attorneys? What kind of judgments and beliefs do we develop about the attorneys based upon our prior experience with attorneys, based upon our prior communications with the staff at attorneys' offices, based upon the cover letters that we receive from the attorneys? I think you'll agree with me that we all develop beliefs, attitudes, and notions and stereotypes about the parties based upon these experiences. Well, what about us as the qualified medical evaluator? Can you believe that the parties, the attorneys, have beliefs about us as qualified medical evaluators? Did you know that claims administrators have beliefs about us based on their past experiences with us as the qualified medical evaluators? Let me ask you, when you walk into the room of the medical legal evaluation, how does the examinee size you up based upon your age, your race, your gender? And I think you can see that there's this mesh of embedded biases that we all bring to the medical legal evaluation. Now, the purpose of this discussion is not to attempt to control the examinee. It's not to attempt to change the claims administrator. It's not an attempt to improve the attorneys. All we can do as medical legal evaluators and the dominion of the Division of Workers' Compensation is to work with us as qualified medical evaluators to make us aware of these issues so that we can properly address these in our own lives and in our own minds so that we can be better medical legal evaluators. So let's talk a little bit more about some of these characteristic targets of bias, and let's specifically explore a case that deals with sizeism, obesity, and large body type persons. Okay, so what I want to share with you now is an actual case. It's a 2021 case that deals with weight and sizeism issue. And this is a case where the Court of Appeal affirmed the WCAB's decision on 80% apportionment to non-industrial factors, including heavy smoking, and here one of the other factors was morbid obesity. So just a couple things before we read from the actual case itself. This is a case that went to the Court of Appeal. Now the hierarchy on this is that first of all, the workers' compensation judge, he agreed with the medical evaluator that Mr. Brophy's, in this case, was total permanent disability, total 100% permanent disability. They agreed that Mr. Brophy had 100% total disability. But the workers' compensation judge apportioned 80% of that disability away to other factors. Well, of course, Brophy, through his attorney, objected and demanded a reconsideration of this finding by the workers' compensation judge. So the matter then went to the next level, which is at the WCAB. The WCAB agreed that 80% apportionment was due to other factors, was non-compensable. There was valid legal apportionment of 80% of the permanent total disability to other factors, including a lifetime history of heavy smoking, morbid obesity, bad diet, and other factors. Well, again, the applicant, Mr. Brophy, demanded a reconsideration and brought it to the Court of Appeal. And finally, the Court of Appeal, this is now 3 layers, all agreed that 80% of the apportionment could be taken away to other factors. So let's read from the case here specifically in our next slide. But important for us now before we move on is that here there was apportionment to these other factors that were argued to be risk factors for injury and risk factors for injury only. And here we find case like the earlier cases mentioned, the Wiest case and the Lynn case, where the courts are now providing for apportionment to risk factors for injury. And this represents a new era in apportionment determinations. And I submit to you that this is something that's going to be subjected to very great scrutiny as we enter now in to the new anti-bias era. Okay, so let's take a look at how this weight and sizeism issue played out into this decision of the Court of Appeal. Okay, so here we have the case. This is the Brody versus the WCAB case. And let's read from this case. The issues involved in this case had to deal with whether the QME's opinion that 80% of the applicant's pulmonary system disability, which was related to obstructive pulmonary disease and hoarse voice, was non-industrial based on his long history of heavy smoking and morbid obesity, whether or not that opinion constituted substantial medical evidence. And you can see the great stakes involved in this determination. In this case, the Court of Appeal affirmed the WCAB's split panel decision. Split panel means two commissioners opined in favor of the support of the workers' compensation judge's opinion, and one panel member was a dissenting panel member. That there was 80% valid non-industrial apportionment of applicant's pulmonary system disability related to his long history of heavy smoking and obesity, and therefore the applicant only received 20% industrial permanent disability due to his industrial toxic exposure that contributed to the lung damage or respiratory system damage. So the facts of this case are that on one specific incident in 2014, the applicant was exposed to toxic paint fumes while unloading a truck. He was diagnosed with COPD and restrictive lung disease. By history, he had a confirmed history of 20 years of heavy smoking and weighed 383 pounds shortly after his specific injury. So you can see that this is an examinee who's a large body type person who could unfortunately be construed or could be perceived as a target of bias due to his size. This person could be subject to sizeism biased, and this is a quite large person at 383 pounds. Well, the qualified medical evaluator determined that the applicant was 100% totally disabled, but found 80% non-industrial apportionment attributable to a lifetime of heavy smoking and morbid obesity. Now, in the qualified medical evaluator's report, the qualified medical evaluator does not talk about how the obesity is contributing to the total permanent disability. He gives no description as to how obesity is causing impairment or disability in any way. However, both the judge, the WCAB, and the Court of Appeal upheld this opinion. And I believe that this is a type of opinion that's going to be subject to even greater scrutiny as we pass now through and officially enter the new anti-bias era. The QME was deposed and reiterated his opinion on apportionment, supported by scientific literature, as the harmful effects of years of heavy smoking had on applicants' lungs, but there is no scientific literature that the qualified medical evaluator relies on in apportioning to the morbid obesity. So he goes on here to support his opinion about the heavy smoking versus the single exposure on an industrial basis, but gives no further discussion about the obesity. Well, the workers' compensation judge's decision is that based on the reporting of the QME, the workers' compensation judge found the applicant to have 80% valid apportionment on a non-industrial basis and only 20% being due to the industrial exposure. Now, the applicant argued that the qualified medical evaluator's opinion did not constitute substantial medical evidence on the basis of apportionment, particularly to heavy smoking and particularly to obesity, but the Workers' Compensation Appeals Board affirmed or held up the workers' compensation's decision, the workers' compensation judge's decision. And here they talk about apportionment to risk factors, and I submit to you that these risk factors, whether they be risk factors due to body size, person's age, person's race, person's nation of origin, etc., are going to be prohibited here in the very, very near future. But here in this case, the Court of Appeals stated, by quoting from the Lynn case, which also dealt with risk factors, where some portion of an injured employee's permanent disability results from a pre-existing asymptomatic condition, and in this case they're referring to asymptomatic lung disease, asymptomatic COPD, asymptomatic restrictive lung disease, that is caused by a non-industrial disease or pathology such as obesity, whether it's caused by congenital or genetic factors or by other non-industrial risk factors is specifically written into this decision, a physician may permissibly apportion the disability. The WCAB pointed out in the Lynn case that the Court of Appeal expressly rejected the Appeals Board's erroneous conclusion that mere non-industrial risk factors that predispose the employee to having, in the Lynn case, left eye blindness, did not constitute a valid basis for apportionment. And the point of this discussion is to show you that in this case, apportionment due to non-industrial obesity was upheld, and the employee's permanent total disability was reduced down to only 20% on the basis of this apportionment. And my prediction is that apportionment to these types of risk factors in the future, meaning the very near future, are going to be prohibited, much as we're going to see that apportionment to other risk factors per se, such as gender, such as diseases that are more prone in males versus females and vice versa, is currently being permitted. This type of apportionment is also going to be prohibited in the very near future. Okay, so let's explore a couple of additional ideas about bias and how bias penetrates and permeates the medical legal evaluation. So we stated in an earlier slide that bias is a prejudice in favor of or against one thing, one person, or a group, and these are the so-called targets of bias. Well, let's see how bias held by and directed toward various groups in the medical legal evaluation can impact the entire evaluation. So as relates to groups, we can turn to Wikipedia for a definition. Bias is a pre-reflective attribution of particular qualities by an individual to a member of some social in-group or some social out-group. So earlier we referred to some of the many different groups that you may belong to, or that you may place yourself in as a member of those groups. I refer to myself as a member of the bald guy group. I'm a member of motorcycle rider groups. I'm a member of weightlifting types of person groups and many other types of groups that you and I belong to. Well, there's a concept known as the in-groups and the out-groups. So according to Wikipedia, bias is a pre-reflective attribution of particular qualities by an individual to a member of some social in-group or some social out-group. So imagine that you are a non-motorcycle rider. So I'm a motorcycle rider. I'm a member of the motorcycle rider group. But if you're not a member of the motorcycle rider group, what are some pre-reflective means before you have a chance to take a moment and think about it, what are some pre-reflective attributions that you have about motorcycle riders? Do you consider motorcycle riders to be menaces in traffic? Do you consider them to be dangerous? Do you consider motorcycle riders to be pesky? Do you consider them to be risk takers? Do you consider them to be loud people if you think about Harley riders that have modified exhaust pipes? What attributions do you have about members of this particular group? And this is just an example where you are not a member of the motorcycle riders group. You're actually a member of the non-motorcycle rider group. Now, me as a motorcycle rider, I tend to think of people that are non-motorcycle riders as slow, as clogging up the road, as being Sunday drivers, as being in my way, as being people who hang me up, as being people who are just not a part of my group. If you know what I'm saying, man. They're not part of my group. So we have these in-groups and out-groups, and we have these groups in the medical legal evaluation as well. So an in-group is a social group to which one identifies as being a member, and an out-group is a social group with which one does not identify. So I'm sure you have many social groups with which you identify and many social groups with which you do not identify. Well, how does this play out in the medical legal evaluation? We have in-groups and out-groups in the medical legal evaluation as well. Well, bias, therefore, is a prejudice against or in favor of one thing, one person, or group, which would be referred to in this case as the out-group, compared with another, which would be the in-group, usually in a way that's considered to be unfair. Biases may be held by an individual, by a group, or an institution, and of course they can have negative consequences. So let's look at how this in-group and out-group bias affects or can affect decision-making, including medical decision-making, in the qualified medical evaluation. Now, social psychologists have long made the distinction between quote-unquote in-group favoritism and quote-unquote out-group negativity, where out-group negativity is the act of punishing or placing burdens upon the out-group. You might be thinking, wow, well, that's kind of heavy. Well, in the medical legal evaluation, we have in-groups. In the medical legal evaluation, we have out-groups. And we're going to see some of these groupings here in just a couple minutes. Social psychologists tell us that there's a significant body of research that exists that attempts to identify the relationship between in-group favoritism and out-group negativity, as well as some of the conditions that will lead to out-group negativity. So imagine that you're a qualified medical evaluator. Do you know this, that you make an assessment of your examinee as to whether or not your examinee exists or can be placed as a member of one of your in-groups, or whether your examinee is completely a member of none of your in-groups, in which case the examinee is a complete out-group member. Well, social psychologists tell us that for those persons that we find to be in our in-group, we tend to opine favorably towards those in our in-group, and we tend to opine negatively against those members outside of our in-group. And this is a form of bias, and I'm going to share with you how this can play out, exactly how it'll play out here in the medical legal evaluation. Okay, so let's imagine that you are in the group of qualified medical evaluators that considers yourself to be an applicant-oriented QME. Have you ever heard this term? You've certainly heard this term, haven't you? Well, if you're an applicant-oriented QME, then the applicant is in your in-group, okay? The applicant attorney is in your in-group. And this is the targets. These become the targets of your favoritism opinions. Now, on the other hand, when you're an applicant-oriented QME, the claims administrator and the defense attorney are members of your out-groups. And so, with regards to the members of your in-groups, social scientists tell us that psychologically we tend to apply favoritism to the members of these groups. So favoritism could manifest itself in the form of a yes opinion on AOE, COE. Favoritism could manifest as a yes opinion on total temporary disability benefits. It could manifest itself as a high or exaggerated or overstated favorable permanent impairment rating. It could manifest itself as a low apportionment determination for non-industrial factors and a high apportionment percentage applied to the industrial injury. These are just a limited set of examples of favoritism towards the in-group when you're an applicant-oriented QME. On the other hand, the poorer members of your out-group, such as the claims administrator and the defense attorney, tend to get punished when you're an applicant-oriented QME, and you'll provide opinions that the examinee is not yet PNS and needs fill in the blank, more treatment, more time, more temporary disability, etc. They need additional diagnostic studies. They need additional total temporary disability. And these parties, the defense attorney and the claims administrator, get punished by the introduction of more delay, more cost, and more time, more uncertainty into the resolution of the case. And this is an example of outgroup negativity. Some of the conditions that lead to either positivity or negativity could be your prior history. Prior history with who? Prior history with examinees just like this, or prior history with this exact same claims administrator in the past, when this exact same claims administrator in the past failed to provide you a cover letter, sent you medical records 10 days after the face-to-face evaluation, and never paid your properly documented medical legal billing. What type of bias are you going to have against that particular type of claims administrator? I can tell you that claims administrator is going to get punished for his or her acts in the past. Okay? So this is an example of an applicant-oriented QME. Let's take a look at what could happen in the case of a defense-oriented QME. Now, in the case of a defense-oriented QME, the tables would be turned to the exact opposite. With a defense-oriented QME, both the examinee and the applicant attorney are now in your outgroups, and these are groups that are going to be punished. They're going to be punished. Whereas the members of the in-group, they're going to be shown favoritism. So for a defense-oriented QME, these types of QMEs tend to opine for denying injury, AOE, COE. They deny benefits. They refer care back to the primary care physician versus the primary treating physician. In other words, they opine for medical treatment on a non-industrial basis. And these particular parties, the examinee and the applicant attorney, receive some measure of punishment because they are members of the QME's outgroup. Now, members of the QME's in-group, including the claims administrator and the defense attorney, see signs of favoritism in the form of opinions for no AOE, COE, no industrial injury, no TTD, no impairment, basically no benefits, reduced benefits, minimal benefits, no benefits. And the claims administrator and the defense attorney are shown favoritism and benefit from the defense-oriented QME. And again, some of the conditions that lead to either positivity or negativity on the basis or the part of the qualified medical evaluator has to deal with our prior experience and our prior history with each and every one of these targets involved in the medical legal evaluation. Now, another of the characteristics that we rely on in placing persons such as examinees either in our in-group or outside of our in-group has to do with our perception of the similarity of our beliefs and belief systems. So some research by these psychology researchers, Struck and Schwartz, found support for what they refer to as the belief congruence theory. It's very, very interesting, and I want you to ask yourself whether or not this is operative in your evaluations as well. So the belief congruence theory concerns itself with the degree of similarity in beliefs, attitudes, and values that are perceived. They may not even be actual similarities, but they're based upon our perceptions. So they're constructed in our own heads and in our own minds. So it's based on the similarity of beliefs, attitudes, and values that are perceived to exist between individuals and groups. This theory states that dissimilarity increases negative orientations towards others, and I'm certain that you can identify this as operative in your own life and even in your own immediate environment. Do you have neighbors who you perceive to have dissimilar beliefs compared to your own? Does this not contribute to negative orientations towards these others? It does. Well, according to Struck and Schwartz, when this concept is applied to racial discrimination, and we can apply this to any other type of discrimination as well, whether it be ageism, sizeism, discrimination against national origin, or any of these characteristic or person targets of bias, the belief congruence theory argues that the perceived dissimilarity of beliefs has more of an impact on racial discrimination than does the race itself. So, stated differently, the discrimination that we impose upon others is not so much based upon their color, their national origin, their religious preference, their sexual orientation, their gender identity. It's not so much based upon that. It's based upon the facts that we consider that these persons have a dissimilarity of beliefs that contrast with our own, and this sets the stage, sets another of the stages for discrimination, for stereotyping, for bias, and ultimately for medical opinions and conclusions from us as qualified medical evaluators that are not accurate, that are not fair, and that are not appropriate for the actual situation. So it's very, very interesting, and because of all of these issues, and because these issues have now come to the forefront of the Division of Workers' Compensation's attention, the DWC is taking certain measures, and let's just review those briefly now. So in an effort to address these issues, at least in the medical legal evaluation, which is the dominion of the Division of Workers' Compensation, there are several measures that are existing and several new measures that are being proposed and will soon be passed in new legislation. So already existing has to deal with the disclosure requirements, CCR 40, which has long been written into law, and this deals with discrimination in the face-to-face evaluation. So the disclosure requirements address the qualified medical evaluator's attitude in the face-to-face evaluation, and this is not new, this is existing. New is new language in California Code of Regulation 11, Section H, which requires at least 2 hours of anti-bias training in order for prospective qualified medical evaluators to sit for the QME competency examination, and this is new. Also new is going to be a mandatory declaration required at the end of our report, which serves as a reminder for all of us that the opinions and conclusions in our QME report are not shaped in any way by bias related to age, gender, national origin, etc. And this is something that's going to be required to be put into your disclosures at the end of your report. And then additionally, on an ongoing basis, the Division of Workers' Compensation is going to require ongoing training in bias and anti-bias issues as part of our every other year QME recredentialing process. So these are new measures here, number 1, number 3, and number 4 here. These are 4 bold attempts by the Division of Workers' Compensation to tackle this issue head on in an effort to train us as qualified medical evaluators on how to be more accurate evaluators. So doctors, isn't that fascinating? Isn't that an eye-opening discussion? It's amazing because all of the parties and all of the players in the medical legal evaluation come to the medical legal evaluation colored by a lifetime of perceptions, attitudes, beliefs, and preconceived notions. And it's incumbent upon us as the captain of the ship, as the quarterback of the case, as the qualified medical evaluator, to at least address these issues to the greatest extent possible that we can in our own selves, to ensure that our final opinions and conclusions are free of bias, are free of stereotyping, and are simply based upon an accurate medical history, an accurate physical examination, an accurate application of principles from the AMA guides and also from applicable case law. Only in this way can we provide appropriate and accurate benefits, neither overstated nor understated, for the parties involved in the case. So the purpose of the DWC's anti-bias plan, and as we enter the new anti-bias era, the overriding purpose and philosophy of this era will be for us to become better evaluators that provide more accurate, more appropriate opinions and conclusions, not based upon anything but the accurate facts. So doctors, I hope this helps you. I want to thank you for taking the time to join me on today's discussion. I look forward to being with you on our next discussion as well. And for now, this is Dr. Perry Carpenter. I'm wishing you best of success in your career as a qualified medical evaluator.